What is about to be shown in this video is not just being shown for the purpose of a conversational point or the next thing to hype about. I highly implore you to actually take actions after watching this video. Awareness of a thing without implementation is no different than intellectual masturbation. That goes on too much. In the 21st century world that you and I live in, the age of technology, fiefdom and serfdom has been completely outsourced to the ones being enslaved themselves. It's been perfected so much that the one being enslaved does not have to be forced by the one doing enslavement, because the one being enslaved is simply not aware of how the system that they are engaged in works. Yet the one who's being enslaved will be the first one to utter out of their mouth, the system this, the system that. You have no more excuse until the first century, if case laws like these exist, to break down the details of how you've been turned into a serf through your daily affairs. Each moment that you take a step, each moment that you breathe, technology is being used against you one way or another. So take action. But the action here is not that you go do something to someone or go point fingers. Most people who know about information are doing that too much. They point fingers. These guys are the bad guys. They role play. They turn themselves into victims and vicariously strip themselves of the power that they ought to hold on to and put to use. What's about to be shown in this video is not being shown to you so you could play victim. It's not being shown to you so you could point fingers. It's being shown to you so you can take action. The best actions that you can ever take, no different than spiritual works, are the ones that you perform on yourself as a form of corrective mechanism. No different than a torpedo seeks its target by groping the space in between it to follow its target even if the target turns. Your awareness when it comes to learning things about how the world works should be the same way. You should correct your trajectory. Don't point at someone else. Don't lay blame and outsource your responsibility of correction to someone else. That's the one thing you can never do. Outsourcing your responsibility of correction. Only you can do that. That's why all these correctional facilities they have don't do anything. Only you can correct yourself. So everything being shown in this video, the solution will be told to you along the way. And the key is for you to implement it. Not to point at someone as a bad guy, not to say that these are some group of people who want to take over the world, not to find another reason to cry, whine, and complain, regardless of age. Because if you say you're in your 30s, 40s, or 50s, what you think you know about how the world is when you grew up is completely different now. So that whole rhetoric of back in my days have no significance here. You are a dinosaur. That's the fact of how things work when it comes to technology. It's moving so fast that if you're 40, 50, even 30, what you think you know about how technology works during the internet age, during the whole flip phone age, whatever it is you take pride in because you're saying back in your days used to be better, all that is trash in today's world. That's the reality of how technology works. It's obsolete. It's moving so fast that if you don't comprehend how it works now, you just be a victim. You have chronological age that's high in numbers, but your mind of how the world works is no different than an infant still crawling. And if you're young, in your 20s, in your early teenage years, it's probably even worse for you because you grew up into that system, desensitized to it. It's like the stages of development. While you're in that stage of development, you don't necessarily see it until something else compels you to look back at the perspective of your prior stage. But your current stage of development, you have to go past it for you to be able to see something relative to it to compare. Most people who are so-called young generations in today's world grew up in this thing. They grew up with technological luxury. They're desensitized to it. So it is evenly applicable to younger generations also. Everything in this video is applicable to everyone, old, young, whatever you say your nationality is, wherever you say you're from, whatever you think you stand for, you are a victim to some people. The people controlling how this thing works don't care the slightest for what you call yourself, who you identify as. All that, believe it or not, is secondary. The primary thing is for you to take individual actions in your life to correct the things that you are leaving out as your power that you're rendering to someone else. And one of those things in 21st century, age of technology, age of information, is your information. Hello, beautiful people. Welcome back. It's best to actually show you what is actively going on, to show you from the perspective of just the general mass, such as articles, and then to show you from the perspective of those who interpret law, called the judicial system. There are two main criteria to be met if one intends to enslave someone else. The first is to give them the illusion of freedom. Second is to ascertain that whatever information you are using against them, the one who is being enslaved must be deprived of that information. Those two things are very crucial. Of the two aforementioned criteria in how to enslave someone, fear is always the seasoning to it. So what I'm about to express in this video is not for the significance of fear. It's more so to let you know that that thing you carry around with you is your handler. No slave master with whip is needed. No duress is needed. No stress is needed. And no coercion is needed. Where technological luxury that people are naturally attracted to is an equation of everyone's daily life. The things that was once done to forcefully obtain certain things from the everyday man does not have to be enforced anymore, because the everyday man are the one voluntarily engaging in an act that's enslaving them. You might want to watch these videos when it comes to privacy and technology to get a slight better understanding as a foundation to this one. The Supreme Court appears worried it could break the internet. The Supreme Court heard oral arguments on Tuesday in a case that could potentially break much of the internet, and seemed to realize the risk of heading down that path. Gonzalez versus Google. Ever so often you will hear me talk about Google this, Google that. When it comes to technology, Google owns the majority of any given type of technology anyone uses in today's world. YouTube is owned by Google. Facebook is owned by Google. Most Android devices by default have backdoors and keyloggers and root programming by Google. Even if you turn it off, even if you take the battery out, that is, if you can. Even if you disable the program, even if you stop running the program, since the root programming is in that device, everything you think you're avoiding, whether you don't want someone to hear your voice or see your face, all that is still nonetheless happening and it's going to the headquarters. After we're done with this video, if you still really don't get it, I highly implore you to go sit down for a little bit and wonder what might be the cause as to why the obvious might still seem a bit blurry. Gonzalez versus Google. The case heard today could subject, by the way, this was released in February 2023. The case heard today could subject social media websites and even search engines. When you see this word search engine, it's not referring to google.com, it's not referring to startpage.com, it's not referring to duckduckgo.com, it's not referring to bing.com. What people don't comprehend with technology, when you see this phrase search engine, it is referring to a function that is not restricted to some hyperlink on a website. That function is inclusive of the applications that run on your phone. That function is inclusive of the items that you use technologically, like the door cameras or the smart refrigerator or smart TV. Anything that uses radio wave to send and receive information can be categorized as a search engine, because information can be ping-ponged and passed through them. If an audio of what you're saying with your spouse is received by your phone, that same audio can be thrown through something called a mesh network into your refrigerators radio wave, which is linked to any type of internet. Absent of it being able to physically search any quote search engine that people know of, where they type, what does a rose look like? What is the weather today? Absent of that, the function of passing information and receiving information is what a search engine is. In case it's not clear, don't worry, if you don't believe what I'm saying, we'll read a case law that clarifies it in black and white. The case heard today could subject social media websites and even social search engines to ruinous liability, potentially forcing these companies to abandon their business model or even shut down. Of course, we know this is not going to happen. The only time any type of plutocratic entity would actually shut down or change their business model is if the one that they're taking advantage of, because information is the greatest value that has ever existed when it comes to human affairs. It still is, and it most likely will be. So long as the ones being taken advantage of are oblivious, they will have no need to change it. Simple as that. Because the purpose of business ultimately is money. And part of making money is having a system and a team to enforce something called a model, business model. And if the people to which the money is being made from through that system enforced by a team and a system by way of business model, if those people don't know, then the business model itself will never change or shut down. Absent of what this article expressing to you, which might sound good, the reality is to the contrary, because the majority of people using technology do not even know how it works. As it's been mentioned in the past, technological luxury is not the same as technological advancement. That said, most of the justices appeared sufficiently spooked, meaning these people who know about the enforcement of law, regardless of whether they appear as though they're honorable or not, even they were a bit baffled, because guess what? They all use technology also. Nothing in today's world can run effectively without electricity. And radio wave is just electricity in the air that we catch in a form that we utilize in a certain manner. All these so-called courthouses, they all have technology. And when they learn about how this thing works, it kind of startled them also. You see why. And if it's startling these wealthy people who know a little bit more than the average man, you, the average man, you probably should be aware of it also, because it is affecting you. What you do not know is affecting you. It is not all right. It is not cool. All that shucking and jiving about, oh yeah, there's nothing to hide, or oh, it's just what's going on for the sake of convenience. You just overlook it. That stuff is not all right in 21st century. You're a human being. You have one of the greatest number of neurons in your brain. Put it to use. Don't be brain dead. Don't insult the divine intelligence that exists in you by just going along with the okie doke. Don't be a horse or a goat who has a rope in their neck, but that rope is not tied to any solid matter, yet it's been conditioned that whenever a rope is in your neck, just stay in one spot. Don't be that. You're better than that. Sure, conditioning is an attribute of human being, and we're creatures of habits, but condition yourself to be aware of how the world around you works. That said, most of the justices appear sufficiently spooked by the possibility that they could destroy how the modern day internet operates, that they are likely to find a way to prevent the outcomes. As Justice Elena Kagan warned at one point during the Gonzalez argument, the justices are, quote, not the 9 greatest experts on the internet, unquote. So it makes sense for them to approach a case that could fundamentally change how foundational websites operate with a degree of humility, meaning they'll use their discretion to say and do things as a finality that favors the ones who are screwing you over. Why? Because you have yet to speak, and these people will not speak on your behalf. Gonzalez concerns Section 230 of the Communications Decency Act of 1996, which is arguably the most important legal provision in the history of the internet. Briefly, Section 230 provides that an, quote, interactive computer service, unquote, is not liable, listen to this, Interactive computer service, like your ISP, your internet service providers, the phone service providers with the phone towers that we've explained in these videos. Is not liable for, quote, any information provided by another information content provider. They're insinuating to you that other phones technologically attached to other services matches and passes and share information no matter how isolated you think they are. And those devices, since they are not sentient, are not responsible for any type of damage caused or damages thereby. I'm not here to say it's right or wrong. That's what's going on right now in 2023. All those people that go protesting, marching, all that. If this were to be the 1960s where people were marching, protesting, or whatever else people do with riots, modern or not, the game of slavery is so perfected that they don't even need to put out water cannon or dogs or police in military attire these days. If you have your phone with you and you go to a gathering, all they have to do is just use MZ catchers to catch the IMEIN SIM card of your phone. If not, then mesh network will tell them exactly who you were, who was there, what you searched, what's in your phone, everything you did, the data and the metadata, when you did it, how you did it. Unless, of course, you're using the Google phones, which we went over on Patreon. Interactive computer service is not liable for any information provided by another information content provider that appears in a servicer's website. Thus, for example, if someone publishes a tweet that unlawfully libels another person, the author of that tweet may be sued for defamation. Twitter cannot. Just an instance, meaning you say someone is ugly, and the platform or the medium of that expression of that information that everyone else would have access to is Twitter. You don't sue Twitter. You sue whoever is saying that man or woman is ugly, or that man or woman did something bad, or that man or woman had done something and you just put it out there. And prior to the mentioned, interactive computer service is not liable for any information provided by other information content provider. If your information is using mesh network to transfer information into other things, into a database, they're telling you that that medium, that platform, those devices cannot be held liable, but the one actually doing it. Platform with your phone and the equivalent of it is, if you're using an iPhone, well, Apple product. If you're using Samsung, whatever it is, Pixel, then Android. Those guys are not held liable, is what they're telling you. So now the question is, who is sending information that other people are knowing about you? Do you even know that in the first instance? I'm here telling you, you ought to. You might say, well, it's not mentioning any of that here. What are you going on about? Don't worry. We'll read the case law that breaks all that down to you. But Section 230 is also a very old law, at least by internet standards. While it protects, and remember, internet is just a portion of Milnet and Nelnet, finally released to the public, which was first used by the military. We went over that in all those other thumbnails of videos that has just been shown. Most of them are on Patreon. Internet is literally just network. That's what the NET after enter stands for. Network. And when information is gathered, transferred, communicated, stored, whatever method, from one point to the other, that is a network. Don't get it twisted that you have to go on Facebook.com or go to your Yahoo Mail or your Gmail in order for the term internet or network to be functional. That's not how technology works in the 21st century. You can walk past another man in a store and your phone will use mesh network to do a handshake with that other man's phone, and your information has been ping-ponged and it will go into a database. Someone else knows who you are, who you came across, what time you came across them, how long you were around them. That's a network right there. Don't misconstrue what the word internet is. But Section 230 is also a very old law, at least by internet standards. While it protects a website like YouTube or Facebook's ability to publish third-party content without being held liable, if that content is unlawful. The plaintiffs in Gonzalez essentially argues that Section 230 does not protect the website's decision to use algorithms. Algorithms are just the command prompts for a computer to behave a certain way. In other words, human provocation. Meaning, I have this in mind as to how I want this to work, so I'll put it in its memory, and from now on it will perpetually behave that way. In simple terms, that's what an algorithm is. It's a fixed law when it comes to behavior and patterns in the computer world. To sort through all the content published on that website, now they're just using website as an example now, and to use those algorithms to recommend certain content to certain users. Okay, some people are probably already familiar with this. You sing a song, you have a conversation, maybe you're talking to yourself based on self-reflection. Okay, all of a sudden a suggestion comes up on your YouTube page. All of a sudden some ad comes up in one of your apps, one of those things where you have to wait 5 seconds to click the X, right? Or you'll go on Facebook and you see some ad, or suggest a group, or says you may know this man or woman, and about 5 minutes ago you spoke to that man or woman's cousin. Mesh network. It's not as far-fetched and speculative as you think. But in this case, they're just moving slowly and just giving you an instance of just a website. Don't worry, it gets deeper, but not for the purpose of fear, for the purpose of you knowing that you are responsible for your future, your safety, and more importantly, your privacy. One of the easiest ways for your futures to be deterred from the right path, one of the easiest ways for your safety to be jeopardized is if you don't take care of your privacy the way that you ought to. While it protects a website like YouTube or Facebook's ability to publish third-party content without being held liable if that content is unlawful, the plaintiffs in Gonzalez essentially argues that Section 230 does not protect a website's decision to use algorithms to sort through all content published on that website, and to use those algorithms to recommend certain content to certain users. Thus, under this theory, though Twitter could not be held liable simply because it allows a user to publish a defamatory tweet, it will lose its legal immunity if the algorithm shows that the tweet to users who might otherwise not have seen it. The potential consequences of this legal theory are breathtaking. If Twitter, YouTube, or Facebook may be held liable for any content that is served to users by one of their algorithms, then these websites may need to dismantle the algorithm that make it possible for users to sort through the billions of videos, tweets, and other content published on these websites. In other words, the normal function of business within what people normally use every day that they rely on and are acclimated to is also tethered to the same function of how your information is taken and used. Just because one man or woman did something wrong doesn't mean they're going to just stop that whole function. When it comes to certain entities, they will use that perspective. But when it comes to you, when one man or woman does something that is in fact wrong, they will create something that will detrimentally affect many more, despite the probability of that repeating itself being very low. The only way they can flip that type of game on people is because people don't really know what's going on. You have to know what's going on. The Gonzalez case itself, for example, claims that Google should be liable because YouTube's algorithm, which Google owns, sometimes serves up ISIS recruitment videos to some users, and thus Google is legally responsible for the attacks that killed American citizens and their lives. The same theory could hamstring search engines too. In any event, many of the justices appeared bothered by the possibility that their decision could prevent much of the internet from functioning. So it is likely, if not entirely certain, that a majority of the justices will find a way to let Google keep its Section 230 protection. although it is not entirely clear how they will do so. And now they're already predicting that, well, Google will get away with it, because many people rely on it and trust it anyway, and many people are not aware of it to demand a sufficient amount of change as an alternative. This is a multi-billion-dollar company, no matter what they might show you publicly as its network or whatever its IPO is. In other words, they have the resource to make things work. Because without the people using it, Google cannot exist. Simple as that. No different than any other business. No different than any other human condition. There has to be some type of faith and trust in its use. Otherwise, it would have no significance. So that's relating to social media and the fact that what you do and how it affects you negatively is seen favorable in light of the business activity of the ones that are basically prostituting your information, selling and buying and making money, so long as you don't know about it. And most importantly, your privacy means nothing, because it's tethered to the function of how the website itself works. Now let's read exactly how Google works and how mesh networks work with your phone. Case 3:19-CR-00130-MHL in the United States District Court for the Eastern District of Virginia, Richmond Division, United States of America versus Okello T. Chatley. Now this is actually not an appeals court case, but as of now, this case still hasn't been overturned. Memorandum opinion. Introduction. A memorandum is just basically a summary of something that's occurred so far and someone saying this is the conclusion of it in form of an opinion of the acting judge. Pay very close attention to how this acting judge introduced everything that they're about to start speaking of. And by the way, the acting judge that signed this was the District Judge Hannah Locke on March 3rd, 2022. Introduction. First few things they mention. Ratified in 1791, the Fourth Amendment to the United States Constitution guarantees to the people the right, quote, to be secured in their persons, houses, papers, and effect against unreasonable searches and seizures, unquote. Make reference to it, Fourth Amendment. To that end, the framers prohibited the issuance of a warrant unless the warrant was based, quote, upon probable cause, unquote, and unless, quote, particularly described the place to be searched and the person or thing to be seized, unquote. The Supreme Court of the United States has since applied the principles embodied in this language to constantly evolving technology. The Supreme Court of the United States has since applied the principles embodied in this language to constantly evolving technology. Remember, it was mentioned a little bit earlier that mesh networks and radio waves are used to transfer your information. An analogy of it when it comes to the transferring of information to third parties that ought not to look at it or see it. In other words, the integrity of your information is being jeopardized. As it applies to websites, there's an anticipation that they will be excused. And that's still going on. There's yet to be a conclusion to that case, Gonzalez versus Google. This case in 2019, they're telling you, look, the requirement of a search warrant for information to be obtained in the evolving realm of technology is applicable in the world of technology that's constantly changing. The question you ought to ask yourself is, whenever these algorithms of computers that's been rooted into the function of your devices that you carry around, technological device, whenever it transfers your information from one place to the other, is that classified as search or seizure? Ask yourself that question. Pause for a moment and think about that. These are the things that seamlessly, that casually occurs every day. As you sleep, as you're awake, as you're eating, as you're taking a shower, your information is constantly being transferred. Whether it's through the cell phone tower,
whether it's through ping-ponging of information until it gets to some headquarters of some type of service provider. And based on the Kalia law, which we've mentioned in many other videos, the local municipal employees, your police departments, have access to all that information based on Kalia, congressional record. They don't even have to use MZ catchers. MZ catchers are basically devices that mimics cell phone towers. We've shown that on Patreon page. There are ways where you can know whether your phone is being attached to an MZ catcher, but that's another subject matter for another day. Basically, it's an app on the phone that basically detects the cell phone tower around you, and then based on the spike of radiation from those towers, because these towers have a fixed amount of activity, but an MZ catcher usually releases a higher than normal activity so that it could mimic it, even though it's relatively small compared to a cell phone tower. If you know what cell phone tower your phone is naturally attached to, you can know when an MZ catcher is being used against you, just based through deductive and inductive reasoning using that app. But that's another thing. I'd rather actually show that rather than just put it in mere words, because it might be difficult for some people to comprehend. But nonetheless, the issue of your information being sent back and forth absent of your awareness, even when you turn the phone off, is that considered search or seizure? I just told you the Supreme Court of the United States has since applied the principles of Fourth Amendment search and seizure and requirement of a warrant and probable cause. They've applied it to the constantly evolving technology, from recording devices in public telephone booths, and then particular to the case law, from recording devices in public telephone booths, Katz versus United States, to terminal imaging equipments, Kylo versus the United States, and most recently to cell site location data, Carpenter versus United States. Do you know what a cell site location data is? We all call that thing a cell phone. I assume we all know what a site is. In world of technology, that's just another word for a target. Targets usually have locations, data, information. In other words, your location can be corroborated with a site, meaning the target, attached to that cell phone as one. Everything in it, they know where you are, what's in it, what's going on, who is around you. The Fourth Amendment principles applies to terminal of imaging equipment. During the whole C-19 thing where they're telling people to stand in front of some tablet that does some facial recognition, or some street cameras, or traffic cameras, or any other cameras, or any surveillance. Fourth Amendment applies to that. From recording a device in public telephone booths, that applies to that. And most recently to cell site location data. And they give you the case laws applicable to those particular instances that the Fourth Amendment applies to. This case implicates the next phase in the court's ongoing effort to apply the tenets underlying Fourth Amendment to previously unimaginable investigatory method. See the reason why we went over what Terry stop is? Because Terry stop was the loophole created for probable cause, and we'll not go over that because we went over about 5 or 6 videos specific to Terry stop. Which is another word for it, investigatory stop. Because in order for you to know that a crime is going on, you have to investigate it. Right. And the probable cause cannot exist until the crime is actually affirmative. And a terror stop is the stepping stone to that, aka investigation. But in the case of technology, no one is physically searching you. No one is physically frisking you. No one is physically saying we have to investigate a crime yet. Your phone is being searched. Information is being gathered, extracted, obtained, and stored. Therefore, the issue of Fourth Amendment is called into question. This case implicates the next phase in the court's ongoing effort to apply the tenets underlying the Fourth Amendment to previously unimaginable investigatory methods. Unimaginable previously. meaning we would have never thought this realm of existence would have come forth. Because most cases when it comes to search are always tethered to municipal employees that are armed and their activities when it comes to physically searching someone. See what I mean when I say in today's world the game is so cold with technology that your physical activities can be found out, and what you have on you and what you're doing, where you went, can be effectively micromanaged by someone else without them even physically touching you, because you already have a handler that you put in your pocket every day. There are people closer to their phones than they are with their hearts. There are people closer to their phone than they are with common sense, and that thing is being used against you. In recent years, technology giant Google, in parentheses, and others have begun collecting detailed swaths of location data from their users. At this point, you now have another party based on a court case telling you, beyond someone else's assumption of what could be easily categorized as just some other new talk as a conversational point, or some other stuff that people are speaking of just to feel special somewhere, just those group of nutcases. This is a court case telling it to you in black and white, as direct as possible, and they're letting you know there's a question of the Constitution involved. In recent years, technology giants Google and others, and it's not just them, have begun collecting detailed, meaning data and metadata, swaths of location data from their users. Where you were, how long you spent there, who else was there with you, what did you do while you were there, what did you say, what did you do on your phone while you were there, so on and so forth. Goes on to say, law enforcement has seized upon the opportunity presented by this informational stockpile, crafting quote-unquote geofence warrants that seeks location data for every user, meaning these municipal employees that would once upon a time physically put traps in places, whether it be traffic or otherwise, or use surveillance cameras, because they say, well, we suspect a gang activity here, so we have to survey it. Okay, they don't even do that anymore. They know these fools will carry their phones with them because they need it. Now, my thing is, whenever something is being used against you, know that there's a way you can use it to your advantage. But you have to know detriment first as a motivation to do better. You have to know better to do better. If you don't know better, you can't do better. Your awareness of what you know about how the world works is what will cause you to take action on it. And if the contrary is the case with you, then the least you cannot say someone hasn't told you. But these people know, okay, we don't even have to do all of that extra stuff anymore. You're going to carry your phone with you, and we can track you directly with that. After that, we'll just go ahead and say, you know what? Now we'll issue something called a geofence warrant, just so we could give a masked and colorable appearance of still being lawful. The question of Constitution is that, how do they know where you were in the first place? Because geofence warrants are based on location data. So that means someone already searched your effect and your property, your information in that phone, to know where you were before that quote geofence warrant was established. Geo, dealing with navigation. Fence, meaning some form of blockade. Law enforcement has seized upon the opportunity presented by this information stockpile, crafting quote geofence warrant that seeks location data for every user within a particular area over a particular span of time. In the coming years, meaning in the future, further case laws will refine precisely whether and to what extent geofence warrants are permissible under the Fourth Amendment. Meaning they have yet to come to an affirmative conclusion of what these municipal armed employees are up to and how to deal with it. You know the reason why they're saying that this thing called geofence warrant could be a detriment, could violate the Fourth Amendment? Because this acting judge knows that there's an underlying factor whereby, in order for someone to quote, to ask for a quote, geofence warrant, that means they must know that their target is in that given area. But the question is, how did they know their target is in that area for them to want to ask for a geofence warrant? Therefore, there's a fine possibility that it violates the Fourth Amendment. In the instant case, meaning in this situation we're dealing with, although the motion to suppress must ultimately be denied, the court concludes that this particular geofence warrant plainly violates the rights enshrined in that amendment. Finding of fact and procedure history. What I'm about to read to you is almost comical because they give you a very fine-tuned detail of how they track whoever this is. During its investigation, law enforcement obtained the instant geofence warrant, hereinafter referred to as warrant, a novel application of search technology whose use has grown exponentially in recent years. This is why you need a de-Googled phone. A de-Googled phone is a phone whereby the root of it is based on something called open source. And all the things that causes these geofence to be possible, whereby your phone is identified with you, your name, your address, date of birth, credit card, your bank account, the last porn website you visited, all that stuff. The Google phones does not have identities attached to that. They will see that the phone name, but who is attached to it and what's going on in the phone, it can't be seen. That's why they call it de-Googled phones. But then there are different types too, and there are many fake ones out there. Google produced certain location information pursuant to the warrant, which led the police to Okello Chatri. Chatri was eventually charged with 2 crimes related to the robbery. He then filed a motion to suppress the geofence warrant that forms the basis of this opinion. At the bottom note, which they will always write something very important, she should always read. Among other things, Google argued in its brief that location history is not a business record. Now, according to the rule of evidence, a business record is admissible, which is what they're alluding to. Location history is not a business record, but, listen to this, but is a journal stored primarily for the user's benefit. Stored by whom? They're saying who it benefits, but who's storing it? And it's controlled by the user. Google states that LH information, and now I'll tell you right off the bat, regardless of whether you toggle that location button on or off, you are still being tracked, especially if you're using iPhones. Google states that LH information, quote, can often reveal a user's location and movement with a much higher degree of precision than cell site location information. What they just gave you here are 2 distinct methods of knowing where you are. One is the location that you toggle on and off, and 2 is cell site location information, which was mentioned above here when it comes to the issue of warrants. And Fourth Amendment issues, cell site location data. Same cell site location data is the other way that you are tracked, regardless of whether you toggle that location button on your phone on or off. And the representatives of Google makes that distinction here that you must know. Google states that LH information, quote, can often reveal a user's location and movement with a much higher degree of precision than cell site location data. Google argues that a geofence is certainly a, quote, search within the meaning of the Fourth Amendment because users have a reasonable expectation of privacy, which, by the way, reasonable expectation of privacy is a doctrine, which we went over on Patreon too. And the LH information. And in summary here, reasonable expectation of privacy says that if you think there's something about you that ought to be private, it is reasonable for you to create that privacy. Otherwise, if you're in a public space and other people happen to come in contact with that information that you purport to be private, then it's not their fault because you should have created the privacy. Defense expert McInville evaluated a sample set of data and found that for that data, location history logged the device's location every 6 minutes. Under McInville's estimate, a user's movement is logged 240 times a day. A user's movement is logged 240 times a day. A log is basically a listing and storing of something that listed in order. 240 times. Someone is taking your activity and storing it, particular to your movement. You really think you're free? I say you are, until you consent otherwise. And you can consent against what your soul is, which is freedom, by lack of information. Hence, an evil known as half cured, which is what's being done here. This is not to instill fear. This is not to make you feel bad. This is just to let you know, hey, your pants are burning. You should probably do something about that. The error code estimate would raise that to 720 times a day. And then 240 is just the minimal, but it can go up to 720 separate times where someone tracks your movement. And Google expert Griff confirms that location history can track a user hundreds, quote unquote, of times a day. These are experts speaking. This is not some opinion of some dude or some lady somewhere that people might consider a conspiracy theory, or some man or woman who got fired and is upset, or someone speculating. No. This is an actual court case with experts from the FBI. Remember, this guy named Dierico was an FBI agent. And McInville and McGriff are experts at Google. So for those who always want everything to be based on what they're comfortable with, they just want their gods to tell them this is what it is. Well, here it is. The experts that many people love so much are telling it to you. It is not being hidden. Google stores this data in a repository. When I tell you they have a database, or when I tell you they have a headquarters where this information is being stored, here it is. Google stores this data in a repository known as Sensor Vault, quote unquote. If someone wants to tell you this in a regular conversation, it would sound very interesting, wouldn't it? By the time you take a few feet of walk away while your phone is tracking you and sending information to someone else, you would have forgotten about it. But here it is in black and white. Google stores this data in a repository known as the Sensor Vault and associates each data. It associates each data point with a unique user account. In other words, it might not use your identity for advertising and just put you on a bucket with other people just as a target market. And marketing and sales is something called target marketing, based on your activity. Okay, they might do that for the making money part. But when it comes to storing your information, make no mistake, your activity and your location is in fact associated uniquely. In other words, Google stores this data in a repository known as the Sensor Vault and associates each data point with a unique user account. Even if you don't log into the Google Play Store or anything else with your email, when you open that phone from the box, it will usually prompt you to put your email in. Even if when you don't do it then and you skip it, at some point you would put your email in. And guess what? Even if you still don't, Mesh Network would identify your laptop, your tablets, that your email has been logged into, and it will identify that information. It gets so deep that even if you don't have any other technological device around you, let's just say that's worst case scenario for them, which benefits you somehow, right? There's something called contact tracing. Meaning anyone who is on your contact list that actually puts your real information, because contact information has an option to put someone's phone number, someone's name, and someone's email, and someone puts your actual email in their contact, even if they're all the way in another part of the world and they are on your contact list, and they use anything related to Google or Apple or Amazon, they corroborate that with your phone number as an identifying information and tag that with your location, even if you're thousands of miles away. Do you see the power of technology so much that the acting judge says location history is powerful? The sensor vault contains a substantial amount of information. McGriff testified that the sensor vault assigns each device a unique device ID, as opposed to personal identifiable Google ID, two different things, and receives and stores all location history data in the sensor vault to be used in ad marketing. At least they're merely downplaying it for the purpose of ads, but many other records show otherwise. Google then builds aggregate models within the sensor vault with data that is transferred so that it no longer looks like user data. Appearance, that is, but the substance of it is still the same. Remember, it tells you here. It contains substantial amount of information. Your identifying information is still there. Whether they mask it later on to appear as something else, again, that it no longer looks like user data, does not change the substance in it. It's like compressing a file or changing the name of a file, but when you open that file itself, the information is still inside, right? And then uses the data to, for instance, assist decision making in Google Maps. As another example, Google uses this data to depict whether certain locations are busy during particular hours, how they go into the stuff that puts you to sleep again, as to, how they use it to benefit you, because you use Google Maps, don't you? Right, so we need that. We need your private information. Do they? They really need your private information. They can collect data of location, sure, but do they have to attach it to private information? Does that violate the Fourth Amendment? These are the questions you should be asking as you're listening to this. Both McGriff and Rodriguez declared that to identify users within the relevant time frame of a geofence, meaning now when someone asks them, hey, we have a warrant particular to this information that you have in your database, give it to us. Google has to compare all the data in the sensor vault in order to identify users within the relevant time frame of a geofence, meaning someone is readily holding information that could be used against you. That didn't used to exist until you consented to it by using certain products. That basically leaves you open, because the reasonable expectation of privacy is up to you. Did you read the user's terms and agreement and conditions and consideration when you opened up that phone? Most people don't. Once a user opts into location history, Google is always collecting data and storing all of the data in its vast sensor vault, even quote unquote, even if the person is not doing anything at all with his or her phone. Even if a user enables location history through an application, meaning you don't directly toggle it on and off. Listen to this. Even if a user enables location history through an application, meaning you don't have to go to that point that says location and turn it on. Certain applications require location to function, otherwise you won't be able to use them, even if it's not Google Maps. If you enable an application to access you, even on the laptop, when you go on a website, it will ask you, do you want this website to access your location? Right, apps, individual apps on your phone do the same thing, regardless of whether you turn location on or off of the settings. Each apps have access to location. The moment each of these apps, which have access to location, which requires that access to even begin to function, the moment those apps themselves have access to location, guess what? Location history will still collect data on the users, because location history is tied to an individual's Google's account, not to a specific app. These apps are snitching on you to your Google account, even if you don't deliberately turn on locations in the settings. Even if a user enables location history through an application and later deletes that app, meaning it's not on your phone anymore, location history will still collect data on the user because location history is tied to an individual's Google account. Your location history is tied to your Google account, not to a specific app. Long after you've deleted that app that required location to function, long after you've deleted it, your location is still being collected because the ultimate source of where it's all going and it's being stored is the Google vast sensor vault, which has root programming into your computer called your cell phone via Google account. Thus, after a user opts into the service, I mean, first of all, think about it. Even if you delete the app and it still collects your information, do you really think just because you turn off or on a location that it stops? Thus, after a user opts into the service, location history tracks the user's location across every app and every device. Listen to this part. And every device associated with the user's account. Did you use that same email to log into your laptop? Did you use that same email to log into your other phone? Right. Mesh network. See what I mean when I'm talking about these things? I'm not making these up. This is a court case telling you and breaking it down to you according to their experts. Approximately 1/3 of all active Google users have location history enabled on their accounts. And we all know enabling or disabling it means nothing at this point. You should know it based on what we've read. So essentially, regardless of whether you turn it on or off, it is enabled. And the location is still collected. In certain circumstances, Google can estimate a device's location down to 3 meters. Location history cannot, but Google can. Location history cannot, however, pinpoint an individual's location with absolute precision. For reference, do you know how close 3 meters is? 3 meters is 118 inches. 118 inches is 9 feet. In certain circumstances, Google can estimate a device's location down to 9 feet. Location history cannot, however, pinpoint an individual's location with absolute precision. Instead, Google estimates a phone's coordinates. GPS, Global Positioning System. Remember those 3 ways that it mentioned as to how you're tracked? Global Positioning System is one of them. When Google, through location history, reports a device's estimated location by placing a point on a map, it also depicts around that point a, quote, confidence interval, a circle of varying sizes, which indicates Google's confidence in its estimation. The smaller the circle around a phone's estimated location, the more confident Google is in that phone's exact location, and vice versa. In general, Google aims to accurately capture roughly 68% of users. Then it goes into how web and app activities are used, meaning when you visit a website, and how applications are used to collect your data. And it affirmatively engages in certain activities. Then it goes into Google location accuracy. Then the same case law goes into whether enabling or disabling location really helps you, which it doesn't, by the way, in summary, in case you are wondering. And how they track you through your phone setup, which I mentioned, through the app. It goes on to detailed history of location history. This PDF is 63 pages long, breaking it down in details. My goodness, it breaks it down succinctly, step by step, without using any sophisticated terms. When you try to delete things, nope, that doesn't work either. When you pause location history, give you a sense of control, nope, that doesn't work either. It goes into all these different details. Google's process in answering geofence warrants. What do they do when these geofence warrants are given to them by your local municipal police? Google warrants represents a quote, novel but rapidly growing technique. Many of these big private corporations, Google is a private entity now. A post was made on Patreon regarding how governmental entities try to subvert constitutional requirements by contracting with private entities. This is one of the ways. But guess what? There are doctrines that are enforceable through 42 USC and tort liability and things of that nature that says if private entities are contracting or are acting in a governmental function, then they can be held liable to the Constitution also. The case law on that was shown on Patreon. When law enforcement seeks a geofence warrant from Google, it 1. Identifies a geographic area, also known as geofence, often a circle with a specified radius. Remember I mentioned about how Google uses a circle radius, right? 2. Identifies a certain span of time, metadata. 3. Requests location history data for all users who were within that area during that time, just so they could know who was affiliated, who you were next to. Mesh networks. The requested time window for these warrants, quote, might span a few minutes or a few hours. Right? A few hours means we don't know. A few hours is that in a database that has information of tens of millions, a few hours could be equivalent to 16,000 hours ago. A few hours is a relative term to what you're looking at in totality. If you're collecting tens of millions of people's information, a few hours could be tens of thousands of hours. In recent years, the numbers of geofence warrants received by Google has increased exponentially. Google received its first in 2016. After that, Google observed over 1,500% increase in the number of geofence requests it received just in 2018 compared to 2017. And the bottom it says, still, concerns about the user interface seems to persist over time. Chat represented what purported to be emails from Google employees generated for other litigation, garnered from other litigation, noting that confusing nature of various location products. On April 1 in April 2019 reads, speaking as a user, WTF ? More specifically, I thought I had location tracking turned off on my phone. Right, that's just your assumption. You thought you had it turned off. Again, you turning your location tracking off means nothing when it comes to the different ways that you are tracked and your information attached to that location and activity. Goes on to say, however, the location toggle in the quick setting was on. Right, you turn it off, but it's still on. So our messaging around this is enough to confuse a privacy-focused Google software engineer. That's not good, quote unquote. The Norwegian report called this phenomenon a phenomenon, right? Deceptive click flow. Meaning the intelligence of your phone can be programmed on a foundational level whereby no matter what you do, you're not controlling it. Whoever created that algorithm is the master of that program, not you. That's why you're called a user. You're just someone else over there that's just using. A user is another term for a consumer. Simple as that. And because of that, you really have no control. Then we go into more details when it comes to intellectual property and so and so. In other words, that program is their intellectual property, which gives them the ability to do one thing or the other. And then they go into step by step of how the geofencing is obtained. Step 1, step 2, step 3, and when it's justified, and how they engage in investigation. This 63-page decision, along with images of what geofencing functionally looks like, I'll be uploading it on the Patreon page. YouTube does not have a medium to upload files and whatnot. They give you all the details. The least you cannot say is an age of technology that the information is not out there. Point of case, the expectation of privacy is on you. So to the question of whether it's actually lawful or not, here it is. The geofencing warrant fails to establish particularized probable cause to search every Google user within the geofence. Although cloaked by the complexities of novel technology, new technology, when stripped of those complexities, then if you just look at the foundation and the summary of what's really going on outside of all the sophisticated technology, this technology, that, what is it actually really doing? This particular geofence warrant, meaning this specific circumstance, lacks sufficient probable cause. It might be different in your case, but this particular, that's why they put it in italics, so that you know we're only looking at this. We're not saying it applies for everyone, but in this circumstance, this particular geofence warrant lacks sufficient probable cause. In other words, it's unconstitutional. It violates the Fourth Amendment. The United States Supreme Court has explained that warrants must establish probable cause that is, quote, particularized with respect to the person to be searched or seized. Remember, geofencing encompasses information of many people based on mesh network. And because you're looking for one man or woman, if you're using geofencing, which collects conglomerate of informations within a given area called the geofence or the location of it, then that violates everyone else's privacy. Now, they're not saying whether it violates that particular man or woman, but the geofencing warrant does not particularize that man or woman. It just takes everyone in that given area. Therefore, it's not particularized with respect to persons to be searched or seized. In other words, it's unconstitutional. To give citation to the principles. This warrant did no such thing. It first sought location information for all Google account owners who entered the geofence over the span of an hour. For those Google accounts, the warrant further sought, quote-unquote, contextual data points with point of travel outside the, unquote, geofence for yet another hour, and those data points retained no geographical restrictions. Astoundingly, the government claims that law enforcement established probable cause to obtain all information, step 1, 2, and 3, from all users within the geofence, and on the footnote they say, in considering whether the geofence warrant is valid, the court assumes for the sake of analysis that the government's collection of data here is, quote, search. See what I mean? All that information that they're taking to the database, all that, the geofence is a search based on the Constitution. Noting that by obtaining a warrant and arguing for the validity of the warrant, quote, the government is treating its proposed capture of information as a search. They're not searching you physically, but your information that they're capturing, that is a search. Indeed, this is the position Google advances in its amicus brief, meaning it was a self-confession of this fact. To be clear, the court sees individuals from whose account the government obtained data as functional subject of the search, and everyone within that geofencing, even though the warrant authorized officers to obtain data only from Google's servers. In the same way that users' devices generate IP address information and typically shares that information with a third party, so too do users' phones generate location history data and share that information with Google. Treating the defendant's IP address as if it were defendant's property that he disclosed to a third party. Your IP address and your information on your phone is your property. In other words, then they're saying, okay, in case you didn't get what we just said, regardless of which entity's file the government looked through, the user ultimately retained at least some joint interest in the location data their phones generate, as discussed in part 3b4. And for, however, because the court ultimately finds that Detective Hilton acted in good faith, meaning, all right, it violated the Constitution, but the detective was acting in good faith nonetheless, which is a way out for them, because there's something called good faith doctrine also, and that's one of the principles to determine qualified immunity. Man, they're setting things up here to the favor of the people who requested a geofence warrant, which is the police. even though they've already said it violated the Constitution. Whether these individuals have an expectation of privacy and that data must be decided another day. That will be the crux. And the reason why they're saying this is because when you're in a public space, there's actually no reasonable expectation of privacy. If you say you're private, then your phone should be the same status. If you say you are private, your phone should be of the same status, because that phone can now be searched and information be seized because you're in a public space. Finding no reasonable expectation of privacy because the defendant discloses IP address to a third party. Yep, and that's called third party doctrine also. We went over this on YouTube also. We also went over this on Patreon. Yet the warrant simply did not include any fact to establish probable cause to collect such broad and intrusive data from each one of these individuals. What invalidates the geofence warrant and makes it unconstitutional is because it's taken everyone's information rather than that particular man or woman as required by the Constitution. Law enforcement attempted to justify the warrant by claiming that such a sweeping search may have tended to identify potential witness and or subject. Even if this court were to assume that a warrant would be justified in the grounds that a search would yield witnesses, some of whom had already been interviewed. Instead of perpetrators, the geofence warrant is completely devoid of any suggestion at all, or even a substantial number of the individuals searched and had particularized the witness of the crime, because that geofence algorithm cannot speak for itself. It's just a program doing what a human told it to do. It cannot sit there as a witness and tell you, yep, these people are likely to be a witness, therefore I collected their information. No, it cannot do that. So no one can come in and present or assert that as a validity to basically screw everyone else's privacy, because they're looking for one or two people around the crowd to say, well, all these other guys might be a witness because they're around him. No, that's inadmissible. To be sure, a fair probability, which is one of the requirements of probable cause, hence probability, which is a very low standard of evidence, by the way. We also went over the fact that probable cause is a standard of evidence in previous videos here on YouTube. To be sure, a fair probability may have existed that the geofence warrant would generate the suspect's location information. Meaning, okay, for it to look at things in light of those people obtaining information, okay, they might be right. However, the warrant on its face also swept an unrestricted location for private citizens who had no reason to incur governmental scrutiny. And there are people indoor in their own houses where there is in fact a reasonable expectation of privacy because they're not in public spaces, yet that circle of geofencing still took their information. Indeed, it is difficult to overstate the breadth of this warrant, particularly in light of the narrowness of the government's probable cause showing. Law enforcement knew only that the perpetrator, quote, had a cell phone in his right hand. They even know what they know whether you have your phone on your right hand or your left hand, and appeared to be speaking with someone on the device. They know who he was talking to. After the police failed to locate the suspect via reviewing camera footage, speaking with witnesses, and pursuing two leads, law enforcement simply drew a circle with a 150-meter radius that encompassed the bank, the entirety of the church and the church's parking lot. You know what surveillance traps looks like in 21st century? Listen to them. For instance, Detective Hilton stated in his affidavit that 1. Surveillance tapes revealed that a suspect used a phone. 2. In the officer's training and experience, when people in concert, they frequently utilize cellular telephones. 3. Google provides electronic communication services to subscribers, including email service. They're indirectly telling you they are accessing your email. 4. Google, quote, has also developed a proprietary operating system for mobile devices. Google has an interest in that thing that you are carrying around as their intellectual property, including cellular phones. You don't really fully own that phone. You're sharecropping its interest, which you signed onto when you activated that phone. Known as Android. Yep. And 5, studies show that 91% of American adults own a cellular phone, with 56% being smartphones. Look at that. They're very confident that they got you, is what they're saying. Because they run this thing in a way that most people don't even know about. What is more, in one instance, this geofence warrant captured location data for a user who may not have been remotely close enough to the bank to participate in or witness the robbery, because the radius of one of the user's confidence intervals stretched to around 387 meters. The geofence warrant might have reported that user's location to the government, notwithstanding the fact that he may have simply been present in any number of nearby locations. And they go and give instances so-and-so as to why geofence is unconstitutional, because it affects other people's privacy. Then it goes on to far more details, especially the bottom notes. These bottom notes are very crucial. Geofence warrant's 3-step process does not cure its defect, meaning the lack of constitutionality. Look at that. Third-party doctrine. We went over this in Patreon. We're not going over it again. It goes on and on and on. But they excuse the detective, though, because he was acting in good faith. Because the information is so novel and so new that we've yet to really have a standard to hold them to that they will be aware of. I'll be uploading the 63-page file on Patreon page. Know what's going on around you. Know how someone else is affecting your life. Just because you cannot see it does not mean it is not affecting you. You get a Faraday bag. Put your phones in it when you're not using it, if you've yet to have a de-ruled phone. Or don't. Up to you. But know that everything that you do or don't do is affecting others, one way or another. You should not be ignorant of how the world works, and you should choose to do better with each day that go by. Until next time, take care. Best of luck.